Good evening and welcome to the Arbitration Academy. As you probably know, but maybe not the students of this year, but the Berthold Goldman Lecture was introduced by Emmanuel Gaillard, the first president of the Arbitration Academy, to explain and to discuss about a seminal arbitration case. And I remember that was always held in this wonderful room, and that was, I remember the first one with the late Johnny Bieder talking about the Alabama case. And then several other outstanding practitioners and scholars were here talking about very impressive cases, and there was always a key moment of every session of the Academy. This year, we will travel to the Southeast Asia, which is not bad at all, and we will be visiting a landmark case, relatively recent, between Malaysia and Singapore. And to deal with that particular arbitration, we have the honor to have a real specialist and a friend of us, who is Lucy Ferguson-Reid. Lucy Reid, I know that she doesn't need an introduction, but let me say a couple of words. Lucy Reid, sometimes the students ask, how can I succeed in arbitration? Or more clearly, how can I become an arbitrator? And sometimes the students take models. And I always say, well, you know, to realize that model, actually, basically the only advice I could provide to you is just work hard. And I could say, to become Lucy Reid, basically you must work, you must have a talent that is not for everyone, but you must basically work a lot. And Lucy was an excellent student, was an excellent civil servant in the State Department of the US. She was very young, acting before the Iran-US tribunal. She was many years partnered Freshfield before she was in other law firms, but she was many years partner and co-head of the arbitration practice and international law practice in Freshfields. But after that, she became the director of the Center for International Law in the National University of Singapore and a professor of arbitration practice in the US University, which is deemed to be the number one in Asia, the number one law school, at least, in Asia. And now she is very active in arbitrations, in particular as in the role of chair of complex arbitration, both investment and commercial, but also as the former, very recent former president of ICA, but also president of important institutions, and in this moment of SIAC, Singapore International Arbitration Center. So it is a long career, very successful, but to become, as I said, to become Lucy Reid, basically you must work a lot. And we are very happy to have Lucy here, because Lucy, for me in particular, that is quite personal. I see Lucy, in addition to a practitioner and to mentor, as a professor, as a scholar. And the last year, she was the opening a very successful partnership we have with Bread and Pratt in Sciences Po. I am a professor in Sciences Po. So it's a partnership we have with Breton Pratt, and Lucy was our first distinguished, Breton Pratt distinguished scholar in international arbitration. And not only the courses were wonderful, I had the opportunity to assist to some courses and lectures she delivered, but she did, for example, she invited individually any student to share a coffee and to talk about the initiatives or the different worries or projects of any single student of the program in the LLM. That was for me really a key notice of the type of person we have here tonight. So we're really proud in the Arbitration Academy to have some outstanding scholar and practitioner delivering this year the Berthold Goldman Lecture, and certainly it's an honor for us, and thank you very much for being here.
Thank you, Diego. Whenever I hear someone list the things I did in my career, I feel really tired. I didn't feel tired at the time, despite all the work, but to hear it listed, it makes me feel a bit tired. So I hope I'll have enough energy. Good evening. I want to thank Diego, thank friends who have come, and in particular, congratulate the Academy graduates as of today for getting through a very rigorous one-month program. And I'm looking forward, I saw a few of you this morning, but I'm looking forward to talking to all of you at the reception afterwards. Congratulations to you. It's a real honor to be giving the Berthold Goldman lecture. I said I would give no more lectures, but I could not say no to this one. Professor Goldman remains a legend in international arbitration. And as Diego mentioned, by tradition, the lecture is to focus on a landmark arbitration award. In other words, my task is to dissect a case for you. And I've chosen a little-known but fascinating case called the Malaysia-Singapore Railway Land Ad Hoc Arbitration. I'll make sure these slides work. That is the railway between Singapore and Malaysia. Now, there are personal reasons why I picked this topic. I do have a personal life. I'll come back to that. One reason is that when I first moved to Singapore in 2014 and was looking for an apartment, my husband and I were looking at an apartment on the 35th floor of a building in Marina Bay. For those of you who know Singapore, this is the heart of the tourist photos that you see, a very lively part of Singapore. And looking down, I saw a big hole in the ground, and I said, what's going to be built? And our real estate agent said, I don't know, some big building. It has to do with an arbitration. And I thought, oh, well, mental note. That's what I do. And we did move into that apartment, and I watched that building go up. Let's see if this will work. There we go. Where's my pointer? This current building was the hole in the ground that I saw from my apartment, and this is what it looked like then. Now there's a second building going up. This is called Marina One. It's a very prestigious and successful building, and it was built with workmen 24/7 for all the years that we lived in this apartment. So I took a particular interest in the arbitration when the award came out because I knew the building. Now, this is the railway line now, and the second personal point I'll make is that I often walked on the railway line, which you'll find out more about over this lecture, but it became a park similar to the High Line, well, a bit similar to the High Line in New York City. So we would often walk there. And pay attention to this sign. This is the signpost for a former station on the railway called Bukatima, which plays a role. So those were my personal reasons, but I have more academic reasons. It's a very unusual case in several respects. So let me start with the dissection. This, I meant to have the slides in front of me. I'm sorry, I have to turn a bit. This is the cover page of the award. It's often informative to start with a cover page because it reveals a great deal. You can see the name of the arbitration in the matter of the railway land arbitration. The parties were the states of Malaysia and Singapore. It was administered by the Permanent Court of Arbitration under the PCA rules, optional rules actually, for interstate disputes, and the origin was a submission agreement between Malaysia and Singapore dated 9 January 2012. This is the second cover page. You can see that the tribunal was a high-profile one. The president was Lord Phillips of Worth Matreverse, who was the inaugural president of the Supreme Court of the United Kingdom, Murray Gleeson, Casey, a Canadian, and Judge Bruno Simma, a German formerly on the ICJ. Now, notice the date of the award, which was 30 October 2014. That's 2.5 years after the submission agreement, which is not bad for a big arbitration. How about the party representatives? Well, I don't have a slide for you for that because the list is 2 pages long, single-spaced. The agents, as is typical, were the Attorney General of Malaysia and the former Attorney General of Singapore, and then a whole roster of other ministers and Attorney General Chambers lawyers. There were also leading public international law ICJ advocates for each side, including for Malaysia, the late James Crawford, QC, and for Singapore, Professor Von Loh, KC, and Toby Landau, KC. There were also leading international firms for each side. For Malaysia, they included Herbert Smith Freehills, including with the then head of DR, Justin D'Agostino, and for Singapore, Debevoise and Plimpton, including Lord Goldsmith, KC, the former Attorney General of the United Kingdom. So what do we have? We have the setting for an unusual arbitration. 2 states with a major dispute voluntarily submitting it to ad hoc arbitration post hoc after the dispute arose. Fielding, to do it, mixed government-private sector legal teams to address a mix of public and private international law and municipal law issues. And hence my chosen focus, which is the challenges illustrated in this award posed when an ad hoc arbitration tribunal must interpret a treaty and manage evidence in an interstate dispute at the interstices of sovereignty and commerce. This is the area where I most like to practice law and where I've been most fortunate to practice law. Now, permit me a few introductory observations, being acutely aware that I am on the record, and I think even being filmed as I speak. The first is that it's increasingly rare for 2 states to submit a dispute to arbitration post hoc. And the submission agreement itself recited that Malaysia and Singapore were proceeding, and I quote, in a very cordial and friendly manner and not in any way acrimonious. Well, that is most welcome. It's even more rare for the losing state voluntarily to comply with an award. Singapore lost, if you will, and immediately announced that it would do so. That is even more welcome. And this is especially the case because, in my personal view, based only on the award and the public record, Singapore seemed to have the better case based both on treaty interpretation principles and the evidence. So in this group, if you like novels with surprise endings, this is the award for you. However, if you like legal cases that you build up evidentiary analytical step, one by one, to a very solid edifice, this may not be the award for you. Let me also offer an important disclaimer or a caveat, which is that I was never, other than standing on the balcony of my apartment, I was never personally involved in this case. And of course, I couldn't dissect it if I were. And I know as well as anyone that a lot goes on during an arbitration that can explain what seems to the award reader to be an unlikely outcome. So I will do my best to be descriptive rather than critical of anyone or anything. So for background, I can be brief, and I'll use, as I say, only the evidence that's described in the award. A preliminary thing you need to know about Singapore property law is in Singapore there's something called the development charge. That is, over time, a 20 to 50% tax that's levied by the government in respect of the increase in value in land that results from a government grant of planning permission to change the use of the land, usually to commercial use. The purpose is for the government and the taxpayers to share the increased value with the developer. And that's important because Singapore is very small and land is at a premium. Now, the development charge was the proximate cause of the dispute in this arbitration, but it also had roots in international relations between Singapore and Malaysia. So I want to get you situated geographically. This is a map. The bigger one is a map of, this is Malaysia here and here, but we don't need to worry about here. This is the main part of Malaysia, and here's Singapore at the very bottom. And expanded Singapore, it's very small for those of you who don't know. It's 24 kilometers this way, and you can drive this way in about 40 minutes. Very small compared to Malaysia. Now, both Singapore and Malaysia were British colonies, and upon independence, Singapore was a state of the called the Malaya Federation in 1963. But then, I'll be very quick, there were race, political, and economic tensions that led Singapore to be expelled from the Malaya Federation. It became independent only in 1965, and it was the founding Prime Minister, Lee Kuan Yew, I believe, who dubbed Singapore to be the little red dot in Asia. Well, actually, I think it was that someone in Malaysia called it a little red dot, and it became a prideful point for Lee Kuan Yew. Obviously, a lot has happened since then. Singapore is a huge success story, but then and now there is an undercurrent of Singapore's reliance on Malaysia for fresh water and other resources. At the time of independence, well, I won't go there yet. I want to show you another map. I'll come back to this map. It's not as complicated as it seems. This is the original railroad line. It comes down from Malaysia. There's a causeway here that takes about 5 minutes to get across, and it enters Singapore at a place called Woodlands. You can ignore the use of the word parcel for now. Then it comes right down the center of Singapore through a part of Singapore called Bukit Timah, where Professor Bell teaches, and then comes down into the central business district where Marina Bay is now. And it ended at what we call the Tanjong Pagar Railway Station. It's also called Keppel, for those of you who looked at the award. I tend to say Tanjong Pagar because that's how I think of it. So before independence, it was an integrated railroad, but after independence, things had to be done differently. I should point out, because this is after independence, because the terminus of the railroad wasn't until the very bottom of Singapore, that's where immigration and customs was done. So Malaysians coming, often day workers in particular, coming into Singapore could do a lot from there to there, including throw a lot of drugs out the window of the train for wrongful purposes in Singapore, which bothered everyone. And also a lot of the route was rough country, relatively rough country, and there were a lot of squatter communities along the railway line. Now pay attention to this, please, that after independence, the Singapore leased the railway lands from Malaysia because it was Malaysian owned. And it was Singapore owned and Malaysia leased the different lands. I think the tribunal called it a bewildering set of leases. They ran from 99 years to 999 years with different types of, I think they were called resumption costs, if ever sold back to Singapore. So some parcels along there were much more valuable than others, you can imagine. And by the 1980s, the railway was no longer profitable, even though day workers were still coming in. Now, with that in mind, that background in mind, I want you to imagine yourself on 27 June 1990 as a fly on the wall in the dining room of Prime Minister Lee Kuan Yew, again, the father of Singapore, entertaining the Malaysian finance minister, Minister Dame, informally discussing various, Malaysia-Singapore issues, and as recorded in a minute that Lee Kuan Yew wrote himself the next day, he suggested that Singapore rip up the railway between Tanjung Pagar and Woodlands. That's between the middle of Singapore and Woodlands, and let Malaysia develop the Tanjung Pagar station down here, which I'll show you a picture of later, as a shopping complex or an office block with, and I quote, it's important, a special low development charge. A special low development charge. This is another map, it's not that different, of the railway line now. You can remember this is Woodlands, this is the Bukit Timah area, and this is Tanjung Pagar. You can see some of the development along there. This is the Tanjung Pagar railway station. It's a heritage building. It's still standing. I can talk about it later if you want. So that's a technical origin to the railway land arbitration. And they ended up with a written points of agreement on Malayan railway land in Singapore. I'll call it the POA, points of agreement, which was reportedly written down by Lee Kuan Yew himself, Prime Minister, and signed on 27 November 1990. Pay attention to the dates, okay? 1990 is 22 years before the submission agreement of 2012. What points were agreed in the 1990 POA? Malaysia agreed to return the railway land to Singapore with no monetary compensation. Just give it back. In exchange, though, 3 parcels of the railway land, I'll go back to my slide, I hope. 3 parcels of old railway land, one in Woodlands, let me go back one more, because now we have parcels, that makes sense. One in Woodlands, one in Kranji, and down here the station at Tanjung Pagar. Those 3 parcels of railway land would be vested in a new Singapore company to be called MS, get it, Malaysia, Singapore, PTE Limited, to be held 60-40 by Malaysia and Singapore, to be established to develop commercial use of those 3 parcels of land. And in the written POA, Singapore said, if you want, Malaysia, instead of taking the station at Tanjung Pagar for development, you could opt for a different plot of land, not a railway land, but a different plot of land of equivalent value in Marina Bay which was it's reclaimed land, it was starting to be developed, and the POA said that the joint company, MS, could develop a prestigious building. So this led to a swap option. The idea that MS Singapore, Malaysia, had 60-40, they could decide. Instead of developing that railway station I showed you, they could get a different piece of land, reclaimed land that was being developed in Marina South. Now pay attention. I'll keep telling you to pay attention to important things. This is paragraph 5 of the POA. Payment for the development costs of these properties will be similarly shared in the ratio of 60-40. That's written down. So now we have an intermission. Life went on, and in what the tribunal called a most unusual feature of the case, 22 years passed before the POA was implemented. In the interim, I'm going back to my map. In the interim, the subway in Singapore opened up here at Woodlands. So now all the day workers coming in from Malaysia could get off, take the subway to wherever they were going in Singapore. And so Malaysia said, it's not so important. We don't really think it's so important that we have the terminus of the railway now be in the middle of Singapore, at what is called Bukit Timah. And there were also all these discussions, quite bewildering, about different possible swaps of land to close this. So when implementation finally started, 22 years later, this is a picture of the two then prime ministers in September 2010. In what was an amended POA, it was agreed that MS, the joint company, owned 60% by Malaysia, would get 6 parcels of land in the south, in Marina South, and a part of it called Ophir Rocher. 6 parcels of land in Marina South that had never been part of the railway lands, in substitution for the original 3 parcels of real railway land in Tanjung Pagar, Kranji, and Woodlands. Plus, Singapore said, we'll throw in an additional 3 parcels of land at Bukit Timah that you can develop, but they're not very valuable, so you can sort of ignore that. And one of the reasons to ignore it is Malaysia and Singapore agreed that MS, the joint company, had to pay the development charge on those 3 little parcels in Bukit Timah because they had been railway land. And they were going to change from being railway land to becoming commercial, so development charge would have to be paid. But what about the development charges for the 6 parcels in Marina South and Ophir Rocher, which were being swapped for the original railway land at supposedly equivalent value, no dollar sign ever put on this, but supposedly equivalent value after planning permission allowed change of the use from railway to commercial development. This proved to be a $1.5 billion dispute, Singapore dollars, which I can best illustrate for you with some photographs. This is the poor old Tanjung Pagar railway station, circa 2011, all shuttered up and not used. And this is the developments that resulted on those 6 parcels of land. The top one's called Duo, or it doesn't matter, but it's at Ophir Rocher, and the bottom ones are the ones I showed you at the beginning. It's Marina 1 and now another building. So extremely, you can imagine how valuable. So now we get to the arbitration. This is the issue submitted to the tribunal for resolution. I know you can read, but read along with me anyway. The question is whether in all the circumstances, including the annex, MSPTE Limited would have been liable to pay development charges on the 3 land parcels, that's Tanjung Pagar, Kranji, and Woodlands, the amount of which has been determined at Singapore dollar 1.47 billion. That's not the value of the land, that's the development charge. If the said parcels had been vested in MSPTE Limited, and if MS had actually developed the railway lands in accordance with the proposed land uses in the POA. So let me translate that for you. In the but-for world, if Malaysia had exercised the original option in the POA for the joint company, MS, to receive Tanjung Pagar, Kranji, and Woodlands parcels of real railway land, and MS had developed them instead of taking the swap for Marina Bay, would MS have had to pay $1.5 billion in development charge to go, it's not railway land, but to develop the swapped land. So the question is, what would have happened if there'd been no swap? Pay attention here, because this sounds entirely in municipal real estate and tax law, but it all turns on interpretation of a treaty. And it's undisputed that the POA is a treaty. The submission agreement itself, Article 2 on the slide, says it's a treaty, and the applicable law will be the POA itself and other international law, and if, to the extent applicable, municipal law. And the tribunal, you can imagine, recited the interpretation principles in Articles 31 and 32 of the Vienna Convention on the Law of Treaties, and went on to say in the award, I'll quote, "In applying these principles," that's Vienna Convention, "it is important not to lose sight of the object of the exercise. This is to identify the common intention of the parties at the time the treaty was concluded as to its meaning and effect." Remember that the tribunal was supposed to be looking for the common intent of Malaysia and Singapore. So the tribunal went on and heard submissions, and I expect read mountains of evidence about the negotiations and Singapore real estate law and practice. I'll review some of it as important today. There were basically, and again, I get this from the award, there were two busy rounds of negotiations, one in 2008 and one in 2010. In 2008, there were ministerial exchanges about swap this, swap that, and there were complex valuations related to the possible swaps prepared by Singapore. Pay attention, this is not dinner diplomacy now. These are real ministers operating in the landscape of valuable real estate transactions in real time. Singapore included in many of its notes to Malaysia what became called the valuation footnote. And this is important, so I want you to read it with me. This is what the footnote says. It's a footnote to a valuation, a number, or various numbers. "This is the estimated value of the land parcels based on their full development potential. MSPTE Limited will need to bear the development charges and other applicable charges and levies before the lands can be developed." Singapore also urged Malaysia to carry out its own valuations of the land parcels. Now, Singapore's Foreign Minister Yeo was one of two witnesses at the hearing, testified that he wrote the valuation footnote himself to reflect the former Prime Minister Lee Kuan Yew's insistence that he had told the Malaysian finance minister at the dinner back in 1990 that the development charge would be payable, and the minister understood that at the time. Now there was, I don't know what happened between 2008 and 2010, but in 2010, the negotiations picked up again. And on the 24th of May, 2010, at the annual Singapore-Malaysia Leaders Retreat, the two states signed a joint statement. And they confirmed first that the Tanjung Pagar railway station would be closed, and the new terminus for the railroad would be up in the north, remember, at Woodlands. And they also agreed that MSPTE Limited, the company, would finally be established for joint commercial projects at sites to be determined. Thereafter, the ministers, again operating mostly on the commercial real estate plane, negotiated on various land parcels and various swaps, also bewildering. But there they went, and by June, the 17th of June, 2010, the Singapore Prime Minister wrote to the Malaysian Prime Minister to offer 3 options. The first 2 involved swapping the original 3 railway lands that you now know the names of, Tanjung Pagar, Woodlands, and Kranji, plus those additional little bits of land in Bukit Timah. That's why, if you've read the award, it's called That's the 3 + 3. For 4 parcels in Marina South and 2 in Ophir Rocher, that's the 4 + 2, which had never been railway land. So it was a swap. The third option that was offered was in line with the original POA, which was that MSPTA Limited would develop the original railway lands and go forward. No swaps. Now, this offer on 17 June 2010 from Singapore expressly says, paragraph 2, as previously indicated, a development charge is payable to realize the potential permissible uses of the 3 + 3 parcels, the old railway land. That would cover all 3 options. Paragraph 4, all proposed developments will be subject to the usual planning approval and development control process under Singapore law. MSPTE Limited will need to bear the development charges and other applicable charges. The mechanism is set out, mechanism for development charges set out in Appendix 3. Appendix 3, there was a paragraph A that said the development charge is estimated for options 1 and 2, the swaps, at about 2 billion Singapore dollars to be paid by MSPTE. And it's higher than 1.5 because there was the development charges for those little Bukit Timah parcels. And B said the development charge is locked down at 1.8 billion to provide certainty and finality to both sides as to what the swap deal comprises and make the deal independent of future changes in development charge or property values. And there were some other notes that went back and forth. And meanwhile, you might want to wonder, what was Malaysia thinking about the $2 billion development charge prospect? Well, that question is actually quite hard. Well, it's not that hard, you'll see. It's odd to answer that, answer that question. Here's what they said in the award. And I quote, "It was only after 24 May 2010, that was the date of the first joint statement of the prime ministers, that the issue in relation to development charge emerged. For this period, and for this period alone, Malaysia has disclosed a series of internal notes prepared by Minister Noor, and he was the head of economic planning in the Prime Minister's office. Those internal notes reflect that the Malaysian ministers considered that Singapore did have discretion to impose the development charge on the lands. One note records, I would think unhelpfully for Malaysia, that when Minister Noor raised the development charge issue with Minister Ma, who was the Singapore Minister for National Development, Minister Ma wrote a letter saying that the development charge obligation had been made clear at the Prime Minister level, and, quote, was not subject to negotiation, end quote. The internal Malaysian notes also reflect that Malaysia made a strategic decision not to discuss development charge in the negotiations with Singapore because they hoped that the whole issue would fall away. Because the tribunal felt Malaysia was surprised at how high the amount was. Well, the issue never fell away, as most $2 billion issues don't just fall away. And there came an agreement. There's the handshake of the prime ministers in September 2010. Malaysia accepted the option to swap the 3+3 for the 4+2 and through MSPTE to develop the by now very valuable projects at Marina South and Ophir Rocher. And they proposed that the development charge issue be arbitrated, and Singapore agreed to that. You have to consider this September agreement to be an amendment to the 1990 POA. So what were the parties' positions in the arbitration? In brief, I'll speak for Singapore now. Point one, in 1990 and 2010, it was clear what development charges would be, so the tribunal need not do more than a classical Vienna Convention interpretation exercise. The parties agreed to create MSPTE Limited as a 60-40 joint venture to develop the railway lands, and per Lee Kuan Yew's note back in 1990, remember, and I quote, similarly share the development costs 60-40. And development costs obviously include development charge. Point two, given this clarity, it's not necessary under the Vienna Convention to consider the negotiations that led to the November 1990 POA. But Lee Kuan Yew actually did submit a witness statement about the dinner with the Malaysian minister, and he testified, he explained what he meant. He said by special low development charges, that those would be lower than a differential land premium that's payable in Singapore to very restrictive covenants on land use, for example, railroad use, which would be 100%. So Lee Kuan Yew said I was giving them a break. Instead of 100% charge, I would be willing to offer a 20 to 50% charge, development charge. And then the point three, if you look to the 2008 and 2010 negotiations I just mentioned, you cannot ignore the express development charge language in the repeated valuation footnotes and in the Singapore Prime Minister's offers, including liquidation of the estimated development charge at 1.8 billion, which Malaysia never challenged in the negotiations. Well, what about Malaysia's position in the arbitration? Well, point one, Malaysia pointed out that the railway land, even though it was an obsolete, unprofitable railroad, did have considerable political, economic, and financial importance for Malaysia, and obviously strategic value because it cuts Singapore in half. So it's got leverage. Point two, the POA terms are clear, and they never expressly mention a development charge, only development costs. Yes, they said Singapore planning permission would be necessary for the developments, but that permission would not enhance the value of the swapped lands, and this is a little tricky, so follow along, because the heart of the deal was that the swapped lands were meant to be equivalent to the value of the railway lands if Malaysia had returned the lands to Singapore for development without any extra compensation payable. In essence, Malaysia put a finger in the air and said, well, the swap was equal. It was going to be equal in value. And as for the 1990 POA negotiations, well, Minister Dam also wrote a witness statement, and he said he didn't remember anything at the dinner about development charges. And about the 2008 negotiations, Malaysia admitted that they understood internally that Singapore could impose the development charge, and they purposefully failed to convey that understanding during the negotiations because they hoped Singapore would cave on the charge. You're probably wondering at this point, why haven't I mentioned money and actual valuations? Given the overlay of politics and this morass of leases, it was perhaps not surprising that Malaysia did not offer any concrete evidence of its own valuation of any of the lands. They offered nothing on the compensation they felt entitled to if they had returned the railway land to Singapore for joint development, or just back to Singapore and get compensated. Not even a ballpark figure, said the tribunal. And this was despite the testimony of the Malaysia Minister Noor that this was a sweet deal, quote unquote, a sweet deal, even if development charge had to be paid. The award suggests to me that the submissions and the evidence regarding equivalent values was at best nebulous, and this room, anyone can fairly ask whether if this was a purely commercial arbitration, Would the tribunal have allowed this lack of discipline in interpreting, applying, and putting a dollar amount on a contract? I won't answer that. Let me turn to what this tribunal did do with the evidence and lack thereof. But first, there's one more thing you need to know about Singapore real estate development law concerning an exemption to the development charge. Something called Rule 4 of the 1996 Planning Rules allows for a development charge exemption in respect of land that is sold by the government of Singapore to somebody else. And Rule 4 reportedly gave effect to an existing practice, which would have been operative in 1990, of not requiring payment of the development charge where the government itself has cleared and sold land to a commercial development under something called the Government Land Sales Program. Why? Why would there be that exemption? Because in these circumstances where the government's entirely in control, the developer's bid price is going to reflect the developed value of the land. So the government of Singapore selling its own land will get a big price and doesn't need a development charge on top of that. Now, based on evidence in the award, Malaysia never mentioned Rule 4 during the negotiations. There's no indication that Rule 4 was ever discussed by Malaysia and Singapore, yet the tribunal relied on Rule 4 to resolve the dispute in Malaysia's favor. The tribunal opined that although Rule 4 is for government land sales, wrong emphasis, government land sales, the purpose underlying Rule 4 to allow Singapore to share in the increased value of developable land through a high sale price, rather than with the development charge, could and should apply to, and I quote, the unique transaction that was the subject of the POA. So what the tribunal did was analogize the POA as a treaty by which Malaysia effectively transferred 3 parcels, Tanjung Pagar, Woodlands, and Kranji, of railway land, to Singapore in exchange for the swap for the other 6 parcels. A transfer and a swap. The tribunal analogized that to a land sale contract. And I won't read the whole thing. What the tribunal did was say it was the POA as a treaty that unlocked the development value of the lands, and found that Malaysia had provided due consideration for its 60% interest in MSPTE Limited by returning all the railway land to Singapore, except sort of virtually the original parcels of railway land as swapped for new land without anybody paying anything more. In my view, this is very undisciplined economics, very undisciplined indeed. And the tribunal talked about a hypothetical sale situation and said that if Malaysia had just given the 3 initial railway land parcels back to Singapore, and I quote here from the slide, had Singapore sold the 3 initial parcels to a company unconnected with Malaysia and Singapore for the purpose of specified development, that buying company would have obtained planning permission without being required to pay a development charge. Well, maybe even probably, but what would the sale price have been? What was the value if all that hypothetical had happened? We know the estimated development charge was for the 3 lands 1.5 billion, but no idea of what the value of a sale would be. Nowhere in the record, any number for a sale price. This is puzzling valuation for me as treaty interpretation of the Lee Kuan Yew dinner, of the original POA, and of the September 2010 joint statement. Especially puzzling because the tribunal accepted expressly that the original POA with Malaysia to retain that, the Tanjung Pagar station for commercial development was clear in obliging MSPTE, the new joint company, to pay a development charge because the railway use was being changed to a valuable shopping center. And the tribunal also accepted that given Singapore's written offers, and especially the valuation footnote, the Singapore representatives, and I quote from the slide, at all times believed that the POA in its original form required MS to pay development charges if it opted to develop the 3 original parcels. And the tribunal did accept that the Malaysian representatives did not challenge this belief on Singapore's part or explain to Singapore at the time, as compared to later in the arbitration, why they thought the development charge should not be payable. The evidence showed they considered it payable, at least by discretion. And the tribunal did note in the award, I don't have it on a slide, they said, we consider that Singapore was justified in challenging this evidence from Malaysia of holding back its position. Indeed. So as I conclude, I want to ask you to recall the tribunal's express intention, and that is not to lose sight of the object of the exercise, to identify the common intention of the parties at the time the treaty was concluded. I emphasize again the word common in common intention. Well, how did that go? Not so well. The tribunal wrote, we have no reason to think that before the matter was raised by Singapore, the Malaysian representatives had given any thought to development charges. As to Singapore's intent, the tribunal found a legal mistake. It's a unilateral legal mistake. The tribunal cited the valuation footnote and said MS would need to bear the development charge in respect of the POA parcels. This assertion was made in good faith and represented the understanding of the Singapore cabinet in the negotiations. But, said the tribunal, unfortunately, as we have found, it was wrong in law. So more accurately, despite Malaysia's ignorance of, or really purposely ignoring, Singapore development charge law and practice, and despite Singapore's repeated and express intention to apply and collect the development charge, Singapore's intention in the POA, when the POA treaty was concluded and amended, was wrong on Singapore law. And so Singapore was not entitled to collect the 1.5 billion development charge on the railway land as swapped. In sum, the tribunal found no agreement on development charge in the POA because it found that there was a common mistake as to its effect in its original form and amended form, induced by an inaccurate statement by Singapore that development charge would be payable under the POA, which Malaysia had not questioned. I'll let that sink in. So to conclude, I submit that this was an inaccurate statement only because of the tribunal's own interpretation of Singapore's municipal law, namely Rule 4, in a treaty case, which likely was prompted in large part, I submit, by the tribunal's desire to even things up between Malaysia and Singapore in an unusual sovereign commercial transaction between neighboring states trying to stay neighborly and perhaps even serve a role of peacekeeper. And in the end, this was perhaps not a surprising outcome, and don't get me wrong, it was not an unhelpful outcome from a tribunal sitting at what I call the unsettled and unmapped crossroads of sovereignty and commerce. Now I'm going to end with a few pictures only to thank you for listening so intently to all that parcel talk. The first is historic view of the railway land. I'm not sure what station that is. This is a modern view of what the trail looks like. You can't, Gary, correct me if I'm wrong, you can't hike the whole length anymore. They're developing very parts of it. But at the beginning, you could hike the whole length. And that's the Bukit Timah station. sign, which has become iconic. And to remind, this is what that turned into in terms of value, but nobody put a dollar value on what the sale price would have been to develop those buildings on those 6 parcels of land. Now, for sheer entertainment, as I started on a personal note, I'm going to end on a personal note, which is, here's a picture of me unfashionably dressed, incredibly unfashionably dressed at the Bukatima sign one day, and on one of the railroad bridges. And what about this one? You're probably puzzled by this one. Well, many students of mine and young lawyers think that I have no personal life at all, that I get up in the morning and I do international arbitration and I go to bed doing international arbitration, and for fun I read Gar, which I don't. But I do have a personal life. And my daughter and my son-in-law are PhD archaeologists in classical world archaeology and art history. So I asked my husband to take a picture of me excavating very carefully, appropriately with a little brush, for a piece of what looked like signal glass from the old railway land in order to show like daughter, like mother, like son-in-law. So that's the end of my discussion of an unusual case at an unusual crossroads with no signal glass as far as I can tell. Thanks for your attention. I'm happy to answer any questions if you have any. Probably can't think of any until it's time, till there's no more time.
Well, thank you very much for this wonderful presentation. And we have time for a couple of questions, comments, if any. A couple.
I can answer a question. You might be thinking, what's happening to the Tanjong Pagar railway station? That poor little orphan in all the talk. It's been closed since 2010. I went to a few art exhibits there, but now it is, the plan is to develop it starting in 2024 as, it's a heritage building, so the outside can't be changed at all, and it'll either be a hotel or a community space or some sort of transport museum. Right now, it's sort of a sore thumb, but it will be put to good use. Otherwise, the railway stations on the line were nothing major. Yes, David.
Lucy, how long was the hearing, and how much was divided into written evidence, oral evidence, and argument by the council?
I wasn't there. But I think it was a week-long hearing, and there were only 2 fact witnesses. Most of it was submissions and going over the evidence. One fact witness was Minister Yeo from Singapore, and there was a witness from Malaysia as well. There were many witness statements, I think, but only 2 live witnesses. Much of it's treaty interpretation, sort of. Anybody else? Let me ask, did I, even though I pretended not to take a position or criticize anyone, did I convince anyone that perhaps the outcome should have been different? Raise your hand if you think the evidence should have gone the other way. I'm reassured, thank you. But as I said at the beginning, to its immense credit, Singapore said, okay, fair and square, no development charge. They didn't get it from MS Singapore. Remember, 40% would have had to be paid by Singapore itself and 60% by Malaysia. We don't appeal, we don't fight, we don't do anything. We go forward. We accept what's happened graciously. And I applaud that. And that is, I've practiced in this area for 45 years, and it's so rare as you all know, to have a commercial party or a government party say, okay, that's what we signed up for, and we'll comply. And that's why I particularly like this case and feel so embedded in the record, and how really, not politically, but really it should have gone a different way by my understanding of treaty interpretation and factual evidence. I guess I should get this picture. Okay, thanks again.
You are all invited to a cup of champagne.